Hey guys, Pouyan Darian here, immigration attorney handling cases nationwide. I'm here to talk to you today about a new USCIS policy that came out on August 5th. Now, a version of this policy previously existed. There were some memos that came out in 2025 that alluded to this, but this new policy basically increases USCIS officer discretion to deny applications without issuing any request for evidence or notice of intent to deny, or even giving you an opportunity for an interview. And the purpose of this, as they claim, is to reduce frivolous filings. If you follow immigration-related news, there is a recent, very large immigration law firm that was engaging in tons of frivolous filings. Frivolous means not based in good faith. Not just weak, but borderline fraudulent or fully fraudulent filings for VAWA cases, Violence Against Women Act cases, which, the name is a bit of a misnomer. It's not just for women, it's for any immigrants who've been abused by a spouse or someone similarly situated. And there's a bunch of other requirements. But anyway, these were getting abused over the past few years. I've seen it myself, so it is absolutely real that this fraud was happening. I was once consulting with a woman and she was asking me if it's safe for her to travel home to Ecuador. And I'm like, how are you traveling home? You've been undocumented here for like 20 years. And she just shows me a work permit that also has advanced parole, which for those of you who don't know means permission to travel internationally. And I look at it and I look at the category and I realize she applied for this based on Violence Against Women Act, VAWA. And so I asked her, I'm like, are you the subject of abuse? She's like, no, what are you talking about? So we do a Freedom of Information Act request and I get a copy of her file and I see like, you totally filed for VAWA, and here's a detailed statement with your signature indicating that you've been subject to all this abuse. And I read the statement to her and she's like, I never said any of that. So it turns out an attorney had prepared that fraudulent filing for her, or I think it was an attorney. It might have been what we call a notario, like people who pretend to be attorneys. I don't remember exactly. This was like maybe a year or two ago. But anyway, she had actually traveled internationally on it 2 times. And around that same time, she had heard that one of her friends who had traveled came back and got detained in the airport. And so that's why she was doing the consultation with me to see, like, is this safe? And my conclusion was, no, it's absolutely not safe. And you should probably withdraw this pending application. I don't know what she did after that. She left the consultation and was not satisfied with what I had told her because I wasn't going to assist her in any meaningful way. But anyway, that's all just to say there are frivolous filings, and my understanding is that USCIS has been dramatically increasing its scrutiny of these VAWA petitions. And that's unfortunate for people who have legit cases, of which there are many. In fact, I'm representing a few people, not that many, like a handful each year, who I think have strong, super legit VAWA cases that are likely to succeed on the merits. So anyway, let's talk about this memo and how it could impact people who are also applying for adjustment of status. So this memo, release date August 5th, 2026, USCIS is clarifying that benefit requesters should establish eligibility for an immigration benefit at the time they file a benefit request. So what I take this to mean is, don't just file an application that's a bare bones application and later wait for a request for evidence. If you do that, they could deny it and place you into removal proceedings before you even get there. Super risky strategy. And we'll talk about some practical takeaways and what you can do if you have an application pending after I read this. Generally, if a benefit requester fails to demonstrate eligibility for a benefit or fails to provide all required initial evidence when filing an application, USCIS may deny their immigration benefit request without first issuing a request for evidence or a notice of intent to deny. USCIS form instructions specify all required initial evidence for every benefit request, giving requesters all the information needed to comply. I'm not sure that last part is totally true. Some of these instructions are garbage, but for the most part, that seems pretty legit. This policy better aligns USCIS procedures with long-standing Department of Homeland Security regulatory authority and form instructions. helps restore integrity to the immigration system, and makes it more difficult for aliens to file frivolous benefit requests. This policy update amends the previous Biden-era policy, which encouraged officers to request evidence before denying a benefit request, even if the benefit requester filed an incomplete application, failed to demonstrate eligibility for the benefit, or failed to provide the initial evidence that was clearly required at the time of filing. This prior policy allowed frivolous or substantially incomplete filings to slow USCIS processing for others waiting in line. Hate to say it, all of that's true. The Biden policy also enabled benefit requesters to exploit the system by filing placeholder applications to gain associated immigration benefits like employment authorization while they waited for a decision on their case. I think here they are straight up referring to the VAWA petitions, because I saw this happening all the time. In some cases, also people who apply for asylum. There was a recent policy that came out that directly addresses this. People would file the form I-589, a bare bones application, and then later on continue to save evidence and update it when it was time for the interview. This was actually common practice. Even really good attorneys were doing this. I had no problem with that strategy because it was what the policy allowed, and it oftentimes allowed us to submit way stronger asylum applications to improve the chances of success while fully complying with the regulations in the law. But anyway, I recently put out a video on how that's no longer a good idea either. And if you have a I-589 asylum application pending with the USCIS field office, now's the time to update it before they straight up refer it to immigration court without giving you an opportunity for an interview. This continues, USCIS has restored officers full discretion to deny a benefit request without first issuing an RFE or notice of intent to deny in various situations. With this updated policy, USCIS can better allocate resources to efficiently make decisions and prevent meritless requests. The policy is effective immediately and applies to requests pending or filed on or after August 5th, 2026, unless otherwise specified by regulations or USCIS policy. So if you have anything pending right now, this applies. I'll give you a straight example, a marriage-based adjustment of status, right? So I've had tons of clients in the past who've said, like, we just got married, we're about to move in together, like next month. Can we just file this now to get the ball rolling? And over the past few months, I would say at least the last year, my general response would be, these cases are moving super fast. It's possible your interview will be in as quick as 3 or 4 months. So I would strongly prefer, if you're living together and we have strong evidence before we file this, because you might only have 3 months to get all the evidence together and make your case strong before the interview. And that advice, turns out, is now more relevant than ever. Because if you have a marriage-based adjustment of status case pending and your plan is to just update all the evidence and make the case stronger right before your interview, which by the way, I do, like I'll file a strong case and then right before the interview, I'll update the evidence. How this memo will change my behavior is, if the case wasn't super strong to begin with, I won't wait until right before the interview to update it. I have one of these right now where they don't have a joint lease agreement. They have tons of photographs. They just have like 1 or 2 months of bank statements. It was an interesting situation. And I just met with them yesterday and I said, like, hey, look, once you have that updated lease agreement in like 2 or 3 weeks, I want to submit an updated submission with more photographs, more bank statements, that lease agreement, and some insurance documents, the things that we've been waiting for while this case has been pending. Because after this memo came out, it's too dangerous to wait until an interview is scheduled to update the evidence. We might not even get there. They might end up denying it beforehand, which would mean they place your spouse into removal proceedings. And if they place your spouse into removal proceedings without an approved I-130, we will probably be out of luck, because you need an approved I-130 to defend your spouse's deportation proceedings. So anyway, this increases the stakes even more, and makes it such that you need to have the strongest application possible at the moment you file. Now, you should still update the evidence and make it stronger right before your interview. But if your case isn't strong from the get-go, you shouldn't wait until the interview to update the evidence. In this case, updating I-130 evidence by submitting unsolicited bona fides of the marriage electronically. Now, I'm curious to see how this might apply to pending N-400 applications. We've been seeing a higher number of N-400s getting denied, and unfortunately, I've also seen some denied N-400s resulting in removal proceedings, which is a totally new thing that was kind of unheard of historically. I just spoke with a guy who had his N-400 denied due to like a really unusual reason. No one could have seen this coming. No attorney would have anticipated this. In fact, he has a really good attorney representing him. And then he received a notice to appear in immigration court saying that we are alleging that you were never a permanent resident to begin with because of some defect in the procedure. Again, no one could have seen this coming. I'm going to do another video specifically on this topic, but I'm curious to see how this policy combined with the good moral character policy could impact N-400 applications. For example, could an officer just straight up deny an N-400 without an interview by saying you haven't submitted enough evidence of good character with your initial N-400 filing? I think that's a bit of a stretch. I would expect some litigation if that happens, but it's not outside of the realm of possibilities based on other things we've seen that might be analogous to that situation. Anyway, guys, I just wanted to create a video on this because I know a lot of people have questions on how this can impact their petitions, their applications, their immigration benefit requests. If you need any assistance with an immigration matter, again, my name is Pouyan Darian. I'm an immigration attorney handling adjustment of status and naturalization cases in all 50 states. You could schedule a consultation by clicking the link in the video description below. I would be more than happy to speak with you, see how I can help you. And if you have questions or comments on other topics you'd like to see me address, throw them in the video comments below. I'll read them before I film new videos, and I hope to see you guys next time for another one.